everybody. This one is about do-it-yourself Kangaroo Courts number 9. Revocation of Signatures. Okay, how these Satanists are assaulting you with one of their so-called contracts and how you can revoke your signature. Kangaroo Court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the court or a bias of the court or other tribunal. This is part 9, so we got parts 1 was talk about all courts, the 2 general kinds, 3 types of jurisdiction, what a kangaroo court is, why they're holding a kangaroo court, what they want you to, why they want you to have a liar, and how to tell it's a kangaroo court, and what they do in a kangaroo court, and why they're Satanists. Part 2 talks about how to tell it's a kangaroo court, more of that, and more of what they do in a kangaroo court, and what's been done by others to defeat their kangaroo court without even going in there. And some things to do if they do drag you in there. Part 3 is why they want you to plea bargain and what happens if you do enter into a plea bargain. And part 4 is it's Roman cult commercial warfare. It's a contract. Where's the contract? Where's the benefits I'm supposed to have taken advantage of that subjects me to this? Admit nothing. Make them prove everything. Object to everything. And reject their contract at allocution. And part 5 is subject to testifying by the liars. And it's an admiralty proceeding, and the so-called judge is a clerk masquerading as a judge. The clerk is sitting there playing stupid. If you do not object, then the bail priest will accept it as true. They're a bunch of Satanists. Part 6 is all courts are United Nations courts operating under UNIDROIT. UNIDROIT's law merchant, the Uniform Commercial Code, and there's no common law because of martial law, and martial law comes about because of bankruptcies, because of military occupations, and because of no money. So there's several ways that martial law can come about. And judges are bought and paid for clerks. They collect a royalty, and they sell you into slavery to populate their prisons and make more money. Part 7, the biggest presumption is they're making you is that you're a U.S. citizen, Sestake Trust slave. And this video is about defeating that presumption, okay? That's called corporate denial. And part 8 is copyrighting the name of the Sestake Trust. It's not necessary to comply with their statutes for a common law copyright. And so the point is you don't have to copyright the name. It helps, but I've never seen anybody ever get a remedy, and it really doesn't discourage them. And there is such a thing as a common law copyright. You don't need their statutes. And this is part 9. The clerk masquerading as a judge forged your signature onto a contract. All this is done under the Satanic United Nations and the Uniform Commercial Code, the UNIDROIT statute, and it's all a fraud, so you revoke your signatures. And this video provides the arguments, the foundation and the arguments and how to do that. So to understand about UNIDROIT, UNIDROIT stands for the Unification of Private Law, and the website says that 63 countries have adopted it. So again, all of this stuff can be used in any country, any of those 63 countries for sure, because UNIDROIT, the Uniform Commercial Code, is the same in every country and in any of those 63 countries. Canada and the United States have been signatories to the UNIDROIT Treaty for over 30 years. UNIDROIT website says that it's designed to be automatically implemented. In other words, the UNIDROIT makes a change, and all the signatories of the treaty are required to make the same changes. And so, again, this would apply in any country that falls under UNIDROIT, any of this UNIDROIT stuff. That's the UNIDROIT website. Getting in a little bit closer, it talks about commercial contracts, cultural property, franchising. Next page, getting a little closer, you notice the header, leasing, security interest, transport, banking law, capital markets, civil procedure, all courts fall under UNIDROIT. Contracts, cultural property, franchising, hotel keepers, insurance, intellectual property, leasing, legal status of women, maintenance obligations, movement of persons, negotiable instruments. Again, this all falls under UNIDROIT. That's why the courts are all UNIDROIT. Covers mandatory insurance for motor vehicles, anything related to marriage, divorce, and children. And this is talks about the 1955 Benelux Treaty on Compulsory Insurance Against Civil Liability in Respect of Motor Vehicles. 1958 Convention Concerning the Recognition and Enforcement of Decisions Relating to Maintenance Obligations Towards Children. And 1959 European Convention on Compulsory Insurance Against Civil Liability in Respect of Motor Vehicles. So all of this has fallen under UNIDROIT. These are some of the member states. It's not all of them. I've only got a couple pages listed here. I think there's 4 or 5 pages, 63 countries. So, but the point I wanted to make here is Australia is, Canada is, and UK is, and United States is, and there's a whole bunch more. Anyways, this is the International Covenant on Civil and Political Rights, Article 2, Clause 1. Each state party to the present covenant undertakes to respect and ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, political or other opinion, national or social origin, property or other birth or other status. Okay, status is Roman law. And this is Article 2, Clause 2, or not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. And so they're saying all states have to do it. International Covenant on Civil and Political Rights, Article 2, Clause 3. Each state party to the present covenant undertakes to ensure that any person whose rights or freedoms as herein recognized or violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity, to ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by legal system of the state to develop the possibilities of judicial remedy, to ensure that the competent authority shall enforce such remedies when granted. And this is Article 3. The state parties to the present covenant undertake to ensure the equal right of men and women. Okay, so they're going to assault everybody with all of their so-called rights. Everyone shall have the right to recognize everywhere as a person. Okay, so they're going to assault everybody with their Sestake Trust. That's Article 16. And now a little interlude. Don't forget to subscribe to this channel. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. And this is my front page of my channel, and the arrow is pointing at the bell so that you know where the bell is that I'm talking about, and make sure and click that and you'll be notified. A little pop-up will come up saying, you know, asking if you want to be notified, and the answer is yes. Anyways, now this is the Law and Customs of War on Land. Okay, Hague Convention 4, Article 42. And so we're talking about a military occupation in this case. Territory is considered occupied when it's actually placed under authority of the hostile army. The occupation extends only to territory where such authority has been established and can be exercised. Now, the reason we're talking about military occupation is that's one of the ways that martial law can be imposed. And anywhere... If you go to the Treaty of the Royal Proclamation of 1763, anywhere west of Quebec at the time, which is very small compared to what it is now, was Indian territory, and anywhere west of the original 13 colonies was Indian territory, and so all of that is under military occupation. Just on the military occupation matter, now anywhere in the British Empire could be considered in the Commonwealth of Nations. Those could all be considered under military occupation because how did Britain go and conquer all these countries? They did it by navy. Okay, that's the only way they can. There's no land connection, and so again, it was all by the Admiralty, by martial law. And so Australia, New Zealand, I mean, all of the British Commonwealth countries were conquered by water. And that's all martial law. Okay, so it's all military, all under occupation. In England in particular, Scotland was occupied. Now, other people might know more history about England, and so there could be other areas in England itself that are under military occupation. But certainly Scotland was occupied because I happen to know about that in history. Anyways, this is so the important thing to understand is there's a lot of places on this planet that are under military occupation. Any place that was ever conquered, okay? Any place that was ever conquered for any reason is under military occupation. And we'll go through how to tell if that occupation ended, but it probably hasn't. Okay, and I'll show you why. Article 2, the Geneva Convention relative to the protection of civilians in time of war of 1949. In addition to the provisions which shall be implemented in peacetime, the present convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them. So this applies to all armed conflicts, whether one of the parties recognizes it or not, whether or not it's declared or not, doesn't matter. The convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets no armed resistance. Okay, so even if there's no armed resistance, and although one of the parties' powers in conflict may not be a party to the present convention, the powers who are parties thereto shall remain bound by it in their mutual relations. They shall furthermore be bound by the convention in relation to the said power, if the latter accepts and applies the provisions thereof. So it doesn't matter whether the both parties are part of the convention or not. Okay, so they have to comply with it anyways. And this is Article 1 of the Libre Code. Any place, a place, district, or country occupied by an army stands, in consequence of the occupation, under the martial law of the invading or occupying army. Whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of the occupation or conquest. The presence of a hostile army proclaims its martial law. Any place that was ever invaded by an armed force is under military occupation. Okay, that's the bottom line. Any place that was ever in the history of the planet invaded by an armed force is under military occupation. Now, how do you tell that the occupation ended? Well, Article 2 of the Libre Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. So, it's either a proclamation, a special proclamation by the Commander-in-Chief, or a mention in the Treaty of Peace. Well, I can tell you, I haven't seen a Treaty of Peace yet that said anything about any military occupation ending. I'll have to look at the Treaty of 1763 when the U.S. and England quit fighting. I should say 1783. But I can tell you that I looked at the Treaty of Hidalgo, and it doesn't say anything about it. Therefore, Arizona, California, New Mexico, Utah, and Colorado are all under military occupation. And I did look in the Oregon Treaty, and it doesn't say anything there, so that's still under military occupation. And it's under martial law. So this is the non-ratification of the 14th Amendment by Judge A.H. Ella to the Utah Supreme Court in the case D.I.Y versus Turner. Now, this book is like about 150 pages, and he goes through and he has the entire Libre Code, and he makes comments on each article, and this is actually a comment on Article 3. And this is directly relevant to any place that's under military occupation, and you'll see why in a minute. Note, under the law martial, only the criminal jurisdiction of a military court is the recognized law. But as Article 3 says, the civil courts can continue wholly or in part as long as the civil jurisdiction does not violate the military orders laid down by the Commander-in-Chief or one of his commanders. By this means, a military venue, jurisdiction, and authority are imposed upon the occupied populace under disguise of the ordinary civil courts and officers of the occupied district or region, because the so-called civil authorities in an occupied district or region may only act at the pleasure of a military authority. And it goes on. It should also be noted here that the several state legislatures, county boards of commissioners, and city councils are constantly legislating to please the edicts of the federal government, the occupying force, and that their legislation in this sense is not an exercise of state sovereignty, but instead a compliance with the edicts of the military force which occupies the several states, and consequently are edicts of martial law rule. Okay, so just because there's a state of Texas, it is under occupation. Okay, and the state of Arizona, that's under occupation, and the state of Utah, that's under occupation, and the state of Oregon and the state of Washington, those are all under military occupation. And Alberta, the province of Alberta, okay, that's under military occupation. Why do they call it the Alberta Court of Appeals instead of the Supreme Court of Alberta, what it used to be called? And because it's all under military occupation, and we'll talk about that in a minute. And this is the concessions of England to the Pope. Okay, so England is under military occupation. We will establish perpetual obligation and concession. We will establish that from the proper and special revenues of our aforesaid kingdoms, and for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 for the Kingdom of England, and 300 for the Kingdom of Ireland. So the point being is that this is tribute. Okay, that means that they're under military occupation, and this is concessions to the Pope. Okay, so the Pope occupied England, and basically King John basically sold the farm, I guess, in 1213. Okay, and so that's martial law, and that's another way that martial law gets imposed: bankruptcy. Okay, and this is U.S. Senate Report number 93-549, dated November 19th, 1973. And notice the date. Since March 9th, 1933, the United States has been a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, and restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule for 40 years. Freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. Now, notice that's March 9th, 1933. Well, get a load of this. This is U.S. Congressional Record, March 17th, 1993, Volume 33. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9th, 1933. March 9th, 1933, same date it went under emergency rule, which is martial law, and declared by President Roosevelt being bankrupt and insolvent. A joint resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States and the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. And again, and that was March 9th, 1933. So at common law, only gold or silver were legal tender, okay? And so again, that's another way that they impose martial law. There are no common law offenses against the United States, no common law crimes. It's evidence of martial law. Only those acts which Congress has forbidden with penalties for disobedience of its commands are crimes, okay? And the same thing in Texas. Under Texas, no law, act, or omission is a crime unless made so by statute. The legislature may create an offense and the same enactment provide exceptions to its application. Offense equals penal, which is a breach of contract. And we're going to talk about that right now, or coming up. Everything is in admiralty. It's under martial law. A root of error doth not lie upon a sentence in admiralty, but an appeal. Okay, that's Tomlin's Law Dictionary, 1835 edition, under the definition of admiralty. But they're citing Book 4 on the Institutes and the Laws of England, which is Coke in the 1500s. Appeals are in admiralty. It's called a court of appeals. Why do you think they call it a court of appeals? It's because it's admiralty. Offense as penal is a breach of contract. It's the same thing that precipitated the War of Independence. This is the causes and necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of law martial. Okay, so again, this is the causes and necessities of taking up arms, and we're going to see how this D.I.Y versus Turner non-ratification of the 14th Amendment by Judge H. Ella to the Utah Supreme Court in the case D.I.Y versus Turner, he explains the same thing in a different way. And he says, in the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. So that's their first order of business, is they got to get rid of this little common law problem, and that's how they do it, okay, is they do the martial law. And that's basically saying the same thing, to supersede the course of common law and instead thereof to publish an order and use the exercise of the law martial. And so they're both saying the same things in different ways. This is the Declaration of Independence. Again, more evidence of martial law for abolishing the free system of English laws in a neighboring province, establishing therein arbitrary government, that's martial law, and enlarging its boundaries so as to render it once an example and fit instrument for introducing the same absolute rule into these colonies. He's abdicated government here by declaring us out of his protection and waging war against us, for imposing taxes on us without our consent, for protecting him by a mock trial. That's all evidence of martial law. And this is, again, the non-ratification of the 14th Amendment. Congress claiming its martial law power to declare war, suppress insurrections, and repel invasions, impose martial law on the United States, and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress. But where is the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc. And it goes on. The 14th Amendment is an extension of the national military powers presently used in a municipal character and enforced by municipal laws stretched far beyond their original limitations and enforced by Article 1 tribunals. Okay, that's Admiralty Court. That's exactly what that is. Canada is the same thing. Okay, here you have an instruction sheet for the social insurance number, and it says make payable in Canadian funds to the Receiver General for Canada. That's a receiver in bankruptcy. Watch the bankrupt corporate so-called governments video. That's why they make statutes for common law crimes like murder, assault, theft, because under martial law there are no crimes unless they make them a crime. That's why they make statutes to protect common law rights, which convert rights into privileges. And now a little interlude, announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 because it avoids the advertising only. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it all. And so, after thinking about it, I was originally going to have some exclusive material on there, but I couldn't think of anything that I want exclusive. So I basically, the only advantage of having this is that you avoid the advertising. It's only $1.99 a month. Great way to make a donation too. And the thing to understand is that I do have some small, I've got an Arlington private information share that's on there that's exclusive, but that's all I've got right now, and I don't know what else I'm going to put exclusively on there. The only thing you can count on is that it won't have advertising. And so I'm currently publishing 6 videos a week, and that's a link. Some people were having trouble finding the channel, so there it is down there. And it's also there at the top of the screen. And some people sent me a donation for $1.99, and I sent them an email and they never did respond. And so I don't know if they wanted me to sign them up or something, and I just got to tell you that I cannot sign anybody up. You have to, YouTube has to make the payment arrangements, and they probably take a piece of the action. And so you got to start your free trial and go through whatever YouTube wants you to do. Sorry. Anyways, back to the topic at hand. That's another thing they do under martial law is they assault you with their liars, okay? He is, however, in a sense, an officer of the state with an obligation to the court. That's found in Book 7, Corpus Juris Secundum, Section 4, on attorneys, okay? And it goes on. His first duty is to the courts and to the public, not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. And that's, again, Book 7, Corpus Juris Secundum, Section 4 on attorneys. And it goes on. It says clients are also called wards of the court. And a ward of the court is an infant or a person of unsound mind. So what a ward of the court's an imbecile. So when you hire one of their liars, you're basically saying, I'm an imbecile and I want this liar to represent me. A ward of the court's not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney is going to make the decisions for you. There's no such thing as an incompetent sovereign. Do you know who you are? If you get anything from one of these liars, he's saying, oh, I got another imbecile here. Let's send him a letter. Okay, that's exactly what they're saying. You know, people only recognize that, I'll tell you. Anyways, all statutes equal contracts equal Roman cult. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. And where an action is founded entirely upon a statute and the only object of it is to recover a penalty or forfeiture, such action is a penal action. And so offense equals penal equals breach of contract. Okay, I got to tell you that is so true. We're going to talk about that right now. The words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture or to be forfeited for non-compliance with an agreement. Okay, it's a contract. The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute and brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. A penal action, and that basically says the same thing as the last one, although it is a different site. But a penal action is a civil suit brought for recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, on the other to actions for private injuries, in which the party aggrieved may by statute recover punitive damages. Okay, so that's why these bail priests, when you nail them down in their kangaroo court and ask them what the nature of the jurisdiction is, they'll tell you it's quasi-criminal, okay? They don't want to tell you it's a civil suit because you could thumb your nose at them. And they'll tell you it's quasi-criminal, but it's really a civil suit. And now a little advertisement. For great custom websites, domain names, and hostings, go to cubeyard.com. Use coupon order code number CY172 for 20% off on your first order. Cubeyard.com, your place for great websites, domain names, and hosting. And back to the topic at hand, Roman cult bar members will represent you whether you like it or not by testifying, and if you do not object, the clerk masquerading as a judge will accept it as true. See Do-It-Yourself Kangaroo Courts 5, testifying by the liars. See Do-It-Yourself Kangaroo Courts 1 and 2 that describe how and when a judge is dealing with a statute, he's a bought and paid for clerk masquerading as a judge. And now another interlude. Check out my other videos. Bankster Thieves 1, 2, and 3, Churchianity series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do-It-Yourself How Not to Volunteer for the Selective Service, Martial Laws here. Do-It-Yourself No Income Tax, Do-It-Yourself No Sales Tax, Do-It-Yourself Traffic Stop 1 and 2, Do-It-Yourself Free Mail 1 and 2, Do-It-Yourself Kangaroo Courts 1, 2, 3, 4, 5, 6, 7, 8, and 9 now. Anyways, whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. Okay, so again, This is Uniform Commercial Code. Remember, we talked about the UNIDROIT Treaty. It's the same in every country that signed on to that UNIDROIT Treaty. And so it creates the presumption. Anything that creates the presumption, unless you defeat the presumption, then they have to keep the presumption and assault you with it. And this is UCC 3-308, proof of signatures. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted, unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming the validity, but the signature is presumed to be authentic and authorized unless the action is to enforce liability of a purported signer and the signer's dead. So the point is that they forge your signature onto a contract, and if you don't even know that it's there, then how can you possibly challenge its existence? Okay, and that's exactly what they do. This is Uniform Commercial Code 8.114, evidentiary rules. The following rules apply in an action on a certificated security against the issuer unless specifically denied in the pleadings. Each signature on a certificated security or in a necessary endorsement is admitted, okay? They sell these things, they create a bond, and they sell it. They forge your signature on it, and then they sell it on Wall Street. That's exactly what they do. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine and authorized, okay? So again, if you don't dispute it, then that's how they sell you into slavery. They forge your signature on all contracts. And so these Roman cult Satanists forge your signature onto a contract and then presume it's authorized and authentic. And who's going to call a judge a liar? They're all a bunch of liars. They're Satanists. That's how they're populating the prisons. Carl Lentz brought up the issue of forgery against CPS when they stole his son in his successful one-page lawsuit. The judge works for the state, the prosecutor works for the state, the police or the witness works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. They're nothing but a bunch of thieves. And notice they got their bail priest uniforms on, eh? The judge on the left, he's got his bail priest uniform. The prosecutor's got his bail priest uniform. And the pig has his Roman cult uniform on. And they're busy fabricating evidence of their slave. Every taxpayer is assessed to K trust having sufficient interest in preventing the abuse of the trust to be recognized in the court of this field's this court's prerogative jurisdiction. That's Henry Bolins. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive Sestike Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And that is a summary taken from 5 pages of the Congressional Record on June 13, 1967. And so this is all coming from the Roman cult. Yet it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nomina fiapes, to the use of the religious houses, thus distinguishing between the possession and the use and receiving the actual profits, while a season of the land remained in the nomina fiape, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. To be bound in conscience to the account for his sestike use for the rents and emoluments of the estate. That is taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Well, think about it. If it's the foundation of modern conveyancing in 1835, it's certainly the foundation of modern conveyancing today. And so, and now another little interlude. Make it so they don't want to, alternatives, I should say. So the alternatives is you got to make it so they don't want to talk to you about their, and you have to see the do-it-yourself estoppel certificates video and file a notice of void judgment into the case, demand a trial by jury, and revoke your signatures from their forged contract. That's what Carl Lentz brought up as the forgery, and when he successfully got his son back, he brought up the issue of the forgery. These people are cowards. These pigs and their bosses are operating a criminal street gang. They're engaging in fraud to get you into one of their so-called contracts. Why do they lie? Because they're cowards. All liars are cowards. They're afraid to tell you the truth. They're afraid to tell you that they're perjuring their oath and they're assaulting you with their so-called contracts. All liars are cowards. And another thing is they cannot use, they're using the Uniform Commercial Code, and they cannot use treaty power internally. This is U.S. Supreme Court, Mayor of New Orleans versus United States. The government of the United States is one of limited powers. It can exercise authority over no subjects except those which have been delegated to it. Congress cannot, by legislation, enlarge the federal jurisdiction, nor can it be enlarged under the treaty-making power. But Madison insisted that just because the power was given to Congress, it did not follow that the treaty power was absolute and unlimited. The President and the Senate lacked the power to dismember the empire. For example, because the exercise of the power must be consistent with the object of the delegation. The object of treaties, in Madison's often repeated formulation, is that the regulation of intercourse with foreign nations and is external. And that's Bond versus United States, 2014. And so then revoke your signatures. And this is one of the cases, or a couple cases you can use as justification. A private citizen does not waive a right unless he does so knowingly and with full appreciation of all circumstances. That's U.S. Supreme Court. All unconscionable contracts are subject to rescission under the common law for failure to make a proper disclosure in order to constitute an acceptance. Where there is no meeting of the minds, there is no contract, as set forth in Maxwell versus Fairbanks, and that's cited in another case. So the point being is that you revoke your signature, okay? It's a fundamental right of a party to have a neutral and detached judge preside over a judicial proceeding, and he wasn't a neutral or detached. It was not a court. The judge was a bought and paid for a clerk masquerading as a judge. It was a kangaroo court. It was a show trial, and they're United Nations Satanist thieves is what they are. At common law, they would be put to death, okay? And this is Deuteronomy 24:7. If a man be found stealing any of his children of the brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die, and thou shalt put evil away from among you. But the watchmen see the sword come, and blow not the trumpet, and the people be not warned. If the sword come and take any person from among them, he's taken away in his iniquity. But his blood will I require at the watchman's hands. This is my effort to make sure I'm blameless on Judgment Day, and I hope you're blameless too. Either you're part of the problem or you're part of the solution. You're now watchmen. Circulate this video far and wide. Copies of these documents can be found in my private group at Yahoo called Administrating-Your-Public-Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. And the last paragraph is for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966. Donations to support this work are appreciated, but they can put their privileges and benefits up their rectal orifice because I prefer gold or silver coin. But as an extremely less desirable alternative, I can accept the IOUs, commercial paper, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. My blog is SovereigntyInternational.wordpress.com. My website is SovereigntyInternational.fyi. My email is engineerwin@yahoo. My YouTube profiles, I got two of them, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group called Sovereignty International is being deleted, but it takes time to ban 17,000 people off of that group, and I'm not going to let Facebook profit by my hard work. Yahoo private group is Administrating Your Public Servants, and my Google private group is Administrating Your Public Servants. I hope you got something out of this. I appreciate you taking time to watch the video, and revoke your signature off the contract. I got some samples on my Yahoo group, or a sample of something you can do, and if you can get it off in the files directory of the Yahoo group. I appreciate you taking the time to watch the video, and have a real nice day.